The question in this case is whether a person can sue under this act to recover damages from the United States government for personal injuries which were sustained during confinement in a federal prison by reason of the negligence of a government employee. For reasons to be developed below, we hold that such suits are within the purview of the Act. This litigation, brought by the government as a single case, arises from two separate suits for personal injuries brought by the two respondents. Both sought damages for personal injuries which were suffered while they were confined in federal prisons. The district judge granted the motions of the government to dismiss in both cases on the ground that such suits were not permitted by the Act. However, the Court of Appeals reversed this decision. Because the decision involves an important question as to the Act, and also because two other courts had previously reached a contrary result, we granted certiorari. Respondent Mack alleged that in April 1959, while he was confined in a United States penitentiary, he began suffering from a condition of dizziness and loss of balance. His symptoms recurred over the next 9 months. He was unable to keep his balance and fell frequently. He also began to suffer periodic loss of vision. Despite many complaints to the prison officers, Mack was given no treatment. In January 1960, his attorney became alarmed by his condition and had him examined by a physician. In February 1960, an operation removed a brain tumor which had caused the troubles at that particular time, but his sight could not be saved. He alleged that the negligence of the prison employees was responsible for the delay in the diagnosis of the tumor and caused his blindness. The other respondent, Blake, alleged that he was, in August 1959, a prisoner in a federal jail. On the afternoon of August 24th, Blake was struck by an inmate and then pursued by 12 inmates into another room. A guard, wishing to confine the fight to one area, locked the room. Blake was attacked and was beaten with chairs until he was unconscious. He sustained a fracture of the skull and lost the vision of his right eye. He alleged that the jailers were negligent in failing to provide guards to prevent the fight. Whether respondents are entitled to bring these suits at this time require us to determine what Congress intended when it passed the Act in 1946. This question would not appear at first glance to be a difficult one. The Act gave the courts jurisdiction of civil actions on claims against the United States for personal injury caused by the negligence of any employee of the government while acting in the scope of his employment under circumstances where the United States, if a private person, would be liable to the claimant in accordance with the law of the place where the act occurred. The Act also provides that the United States shall be liable respecting the provisions of this title relating to tort claims in the same manner and to the same extent as a private individual under like circumstances. Congress qualified this general waiver of immunity by omitting from the Act claims arising from certain government activity. So far as it appears from the face of the Act, Congress has clearly consented to suits such as those involved in the case at bar. Whether a claim could be made out would depend upon whether an individual under like circumstances would be liable under state law, but prisoners are at least not prohibited from suing, since a number of lower courts have nevertheless reached a contrary conclusion. We deem it appropriate to make a more detailed investigation into the intent of Congress. An examination of the history of the Act reinforces our conclusion that Congress intended to permit such suits. For a number of reasons, it appears that Congress was well aware of claims by federal prisoners and that its failure to exclude them from the provisions of the Act was deliberate. The Act was designed not only to avoid injustice to those having claims hitherto barred, but to ease the burden on Congress of passing upon private bills. Considering the plain import of the statutory language, we believe it is clear that Congress intended to waive sovereign immunity in cases arising from the claims of prisoners. We are loath to believe that the possible abuses stemming from the suits of prisoners are so serious that all chance of recovery should be denied. It is possible, as the government suggests, that frivolous suits will be brought, and it is possible that the government will be subject to the burden of pretrial preparation. This seems to be a concomitant of any form of liability. Too fast?
No, it's okay. How do you spell concomitant?
C-O-N-C-O-M-I-T-A-N-T.
How do you write it?
I read it to K and then com and then tent.
Tats with a A.
What? Yeah, with an A. There was 155. It's pretty snappy for a legal opinion. Want to read some? On the other hand, let's I got